the Bryan Kohberger case, they were in court last week to talk about the surveys that came to the attention of the prosecution. The defense was sending out surveys and finished their surveying in Latah County, where this court sits, where these murders happened. The defense has a pending motion for change of venue. The defense was very clear in citing the case law that said to show or to get a change of venue, you have to show that there is more than just a lot of publicity, right? Just a lot of publicity is not going to do it. You have to show more. And so Ann Taylor has argued that to show more, you need to show that jurors or potential jurors in the jury pool have been impacted. Ann Taylor hired an expert to help determine how many people needed to be surveyed, to craft those surveys, and then hired a separate firm to go ahead and start cold calling potential jurors, so the population over 18 that could be on the jury rolls, and asking them general questions and then more specific questions. And the more specific questions came to the attention of the prosecution, and the prosecution went, "What are you asking?" The prosecution did not argue that the survey's not allowed, that these types of surveys can't be used, that any of the questions in the survey violated rules of court, local laws, case law, or anything like that. The entire argument was whether or not the specific questions on the survey violated the non-dissemination order in the case. That is the question. And I know a lot of us were sitting here going, those questions though, but the prosecution never argued that the questions are improper of anything other than the non-dissemination order. And that's what they are talking about today, and to try to see if any of the survey can be salvaged.
For example, a professor who was accused by a psychic of being responsible for this.
The TikTok psychic case, that goes to court next week. We're going to talk about it next week, but the TikTok psychic case has made it into court. Y'all.
Reduced amount of weight because the state is not in a position to respond to any of this.
Yeah, okay.
Thank you. But you'll have an opportunity to respond to any of this before I make a decision.
Not today, Judge. This goes. I'm sorry.
Hold on.
It would be so much easier if we could see all of you. Not today, Judge. Not today, Judge. Oh, he just like Santa, not today, Satan, the court. Not today, Judge. Again, I think we have a miscommunication here because Bill's objection, and since Ann's calling everyone by first names, I'm also joining in that trend, just to keep with the local vibe and feel of this courtroom. So Bill said, I have an objection. This is starting to get into what would be the motion for change of venue. And we are not prepared to respond to the motion for change of venue that hasn't even happened yet. The defense has not done their briefing. The state has not done their briefing. The defense has not done responsive briefing. They have not had a hearing, none of that. And the judge responded with, well, you'll get a chance to respond later. And he's like, not today, Judge, because he thinks the judge is talking about the motion to change venue, not about these surveys. And I think, again, they are misunderstanding each other, but it's hard to tell when I can't see their face.
So when you're talking about slide number 33, slide number 31, that's not the intent. And it's certainly
dramatic.
I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told, watching on a Zoom, that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay. And yes, it doesn't matter.
I'm not crying. I'm angry.
And please go ahead and be as angry as you like as you continue your work for the defense in this case.
Oh my God.
It is a fact, though, that you don't know of the, 400 citizens that were.
Santa has said not today, Judge, and stay mad. Like, oh, Santa, it's a little heavy-handed, sir. You're the prosecutor. Over 2 hours and 40 minutes of the quick hearing that was scheduled for 4 p.m. PST in Idaho, wherein the expert did finally testify, then had a extensive colloquy with Judge, who had some things he wanted to say and was curious about. It was a very fiery hearing. The expert is clearly offended by the prosecution insinuating that the jury pool had been tainted by the questions, was clearly offended that the media picked up and ran with the fact that the defense is in hot water, or that this was an improper survey, or that the questions were questionable, or whatever. The expert and the judge and the prosecution and the defense were all a bit feisty with one another. The point of the hearing was to determine if questions in the survey violated the non-dissemination order. And the judge decided nothing at all, and is going to be issuing a ruling later. So we don't know if the judge has determined that any of the questions violated the non-dissemination order. We have found a massive communication error between what the court considers the public record and what the defense considered the public record. The defense is trying to survey what the potential jury pool knows that is out in the public, either through media reporting, media headlines, whether that came from the court record or from wild media speculation as they, spin around in circles and talk about the case. And the expert explained, right, but if those things are out there, we need to know if they have influenced a potential jury pool in a way that makes it impossible to pick a jury here. And the prosecution has said, but does that violate the court order? And the court has said, the public record is the literal documents on the court record that has been released publicly, and some of the questions on the survey are not from or founded in that court record, even though they are in the media. And the expert explained that some of the most difficult things to overcome in the media are things that are false and highly prejudicial. And some of those questions are included in the survey. The defense seemed very frustrated. The expert seemed very frustrated. The prosecution's cross-examination was the fieriest thing I've ever seen the prosecutor Bill do in court. He was mad. I mean, the defense did use his press conference in their PowerPoint to suggest that the prosecution called for the dissemination of the probable cause affidavit, and that was the beginning of the problems. So maybe that's why he was so feisty. As he was miscommunicating with the judge at the end of the day, at one point, the judge said, well, you'll have a chance to respond. And he was like, not today, Judge. Because the issue is being conflated between the surveys and the change of venue motion, because they go hand in hand. And the prosecution wants to make clear there's an answer about whether the surveys can continue and with which questions, or whether they have to stop. The defense and the defense expert want to continue their work. This goes all the way back to the beginning of the case when defense attorney Ann Taylor said, Your Honor, we're having a problem finding people who want to work with us because of the high profile nature of this case. So her concerns go all the way back to the beginning of this case when she was talking about the difficulty the defense was having in finding experts to work with them. And I understand that. So at the end of the day, lots of talking happened in court, and nothing was decided yet, except that the change of venue motion will not be heard in May, and it has been kicked out to at least June 27th, depending on when and what the judge rules on and how long the briefing schedule takes. So sometime in June, we will hear a change of venue motion. And I'm not confident that there will be a ruling on it or that the judge won't turn around and say, and I said this when he decided he wanted to explore this avenue, that I'm not confident that Judge isn't going to say, you know what? I think it's too early to determine a change of venue because this trial is not even set yet. I very much worry that at the end of all of this, Judge is going to come back with you know what? We should do this closer in time to the actual trial. That is my concern here. But we will see what this judge does. He sure does like having a chat with the lawyers and talking through the process. The lawyers today, though, were less than thrilled. So they are back in court in May for another hearing on a motion to compel. We should still see the alibi filings on time. We might see the unsealing of a prosecution document that they had made a motion to unseal, but the defense has asked for some redactions. We'll see. But we already know the answer to the looming question about whether this defendant can find a jury that is unbiased in Latah County, and it is already the defense's position that that is not going to be possible. But we kind of suspected that was going to happen, didn't we? For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.